Well, hello. I would say happy Friday, but it's a crazy Friday. We knew it would be. We knew all these things were due today and that they would be coming in late as always. So I haven't even gotten a chance to look at anything new. I was interviewing with Bocce last night for her next 17 questions with Bocce series. And we knew it would be long because both of us we have the longest content, I think, of all of the creators in this community. So putting us together was interesting indeed. We were on until almost 2:30 my time. It was crazy. So, and then I couldn't sleep in today. I was babysitting a 4-year-old relative and that was busy. So I couldn't get to this. So I was up after I spoke to Bocce for so long. Then I was trying to finish writing this. Of course, I didn't finish. It was already light out when I went to bed. So I only got a few hours of sleep, maybe 3 hours of sleep, and then just was running all day. And then finally sat down for the last about two hours to try to finish writing this. So unfortunately, and I didn't want to put it off another day though, because we got all these new things to consider throughout the weekend. And this will be old news really, really fast. But also it makes me so angry and I don't want to dwell on it one more time. Is there something wrong with the sound? Jungle Vet Jill says sound. But Ricardo. Hi, Miss Cass. Hello, lovelies. The lapdog has me dizzy. Oh my goodness. He has me furious. I think it's good that I didn't do this last night because I was so angry. And you know how I get when I'm angry. I cry. I just hate it. Okay, thanks. The sound is good. Okay, I didn't know what that meant. Maybe that wasn't to me. Maybe it was to somebody else. But today, hopefully I'm too tired to get that worked up over it. But the problem is the first half that I wrote last night, I didn't have enough time because I didn't want to go too late. I didn't have enough time to read over, so I'm not real familiar with it. I wrote it yesterday, really late, divided up between a little before and a little after the interview with Bocce. So it's probably not going to flow as smoothly as I wish it would. So please bear with me. I will be reading off of the notes that I wrote last night for at least more than the first half of it. So anyway, the inspiration for this thumbnail, I usually like to talk about those, is the idea is that he's trying to make something fit that just is not going to cover what he's trying to make it cover. But and so this cover sheet, whatever he's trying to make put over it, represents the cases that he's trying to use to make this cover what he wants it to cover. And so we see him struggling, we see him pulling. I imagine him having fat little fists. Oh no. Angry Petty Cassie's coming out. I'm not going to be nice. I am not going to be nice. I have been, some people think I'm too mean to this man, but after all of this, I think maybe I haven't been mean enough. And then I saw someone on X and I forgot to crop the whole post so I could shout out the person, but I think that it's Joyfully Observed. I don't know if you guys know who that is, but she has excellent posts on X that I just love. And I think that it was her that posted this picture. And I had never seen this. I keep reusing like the same 2 pictures of her pre-surgery. And so I was thrilled to see this one because it was one I had never seen this before. I don't know where she found it, but I was thrilled that she did. And so I just had to to add that in there just as one little I've seen a lot of people say, and I can't remember if it was in this post that had this picture. I think it was. I just don't want to misquote. I want to say that people have mentioned that when you change your appearance this drastically, you have some level of self-loathing. You are not happy with who you are. If you're going to go through every feature of her face is different. It's not dark yet. No, after dark, Cassidy. Ricardo says, Cassidy, it's not dark yet. Thank you again, Ricardo. So I will be ignoring chat for the most part because I want to get through this. And like I said, I didn't get a chance to run through all this, and I feel like it won't be smooth if I take my eyes off of my notes. I will forget what it was that I wanted to say about each slide. But yeah, I was so angry. I just wanted to just be petty and just be like, oh, what I was saying, her face. Every feature, literally every feature of this woman's face has been surgically altered. She didn't just get a nose job. Her mouth is distinctively different. And this is after she fixed her teeth were really out of control when she was younger. So this is like after she's already done that, but she completely has changed her mouth, completely has changed her nose, and looks like she had surgery for looks like her eyes are pretty hooded here. And so she's definitely, and that's every single feature on your face that she has changed. So this is not a happy person. This is a fake person. Everything about her is appearance, and it's all fake. But we see the ugly behind it all. And I'm not calling her ugly in this picture. She's still not ugly in this picture, I don't think. But it's not what she looks like. Yeah, the chin, the face shape, so much. It's like everything. Everything. Yeah, breast surgery too. Yeah. So that is someone who is not happy with themselves. But this order, this denial of the motion for summary judgment that he granted them, that he basically told them to do, but by his response, and I know there are people who criticize, and it upsets me. I don't like to hear it because especially if it's someone who is new to this case, who has not been here through it all, didn't see the how and the why things happened from the beginning. I think it's just not nice to come in at the end knowing everything that you know now, like way after the fact, and then criticizing things that happened before people had all the knowledge that they have now. It's not a fair criticism. And it's also someone who has criticized some of our dear favorite attorneys that speak on this case. One of the ones I really, really like is Brittany Kay, Commit to the Brit. And she has attacked her over and over again. So, yeah, I don't put much stock, but I did want to apologize because somebody had mentioned this person, and I don't want to say the name, who criticizes. And my response, it sounded short, but it wasn't directed at the person who mentioned her. It was directed at the person, that her, not the commenter, because she's nasty to other people. And I think when you come into a community that has existed for well over a year without you, people have content creators that they like very much. Those of you here always commenting in the community, we're used to your names, your comments. We love your comments. We laugh together. We don't like to see any, whether it's a creator or a commenter, being attacked by someone, especially someone that's just walked into the case. And so, yeah, I just want to apologize if it seemed like I was snapping at you, the person who put that in comments. I apologize. I'm sorry. I didn't mean that in a snappish way towards you. It was just about that. Like, because reading this order, honestly, I don't believe that there was any way that Wayfarer could have responded that would have brought a favorable response from Judge Lyman. Just, I really, truly, with all of my heart, do not believe there was anything they could have said that he would have said, "Oh, yeah, that's it," and granted it. I just don't. I don't even know why he did, unless he was. I've seen some people wonder if it was maybe to make it appeal proof, like, well, I gave them this extra chance. They can't appeal this now. Maybe, I don't know. But it could be. But so his order to me, it looked angry. It looked like, how dare you? Because I've already said this is how it is. I said it fits and it fits. Don't tell me it doesn't fit. I felt like a little bit of that. Like, this court has already ruled, blah, blah, blah. And you come and forget the fact that I'm gonna get ahead of myself there. So I'm gonna back off of that real quick and go back to my notes here. But what it looks like, besides of him being angry, is that it looks like, instead of the approach that you're supposed to take, which is, okay, I have a document from this side that says this, 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 and has this case law to support it, and these rules listed, and then I have an opposing brief or motion, whatever it may be, saying the exact opposite and has case law and rules to support that side. So how do I decide? Well, I have to start with the rules and the case law. And I've got to look at the binding authority first and then work my way down. If there's nothing from the Supreme Court, I move to the Court of Appeals, the U.S. Court of Appeals. If there's nothing in that, then I can go on down to my low level, my district level of court, and look at persuasive authority. That's how it's supposed to go. You are not supposed to go into making a decision with a preconceived idea of what you want your answer to be. And then grab this case law and this unpublished case law. We see that again. We saw that before, didn't we? When he tried to make something fit that shouldn't have fit. This is crazy to me. The second time in this case, we've seen him resort to unpublished law. Why is he doing that? Is it because there is a lack of actual case law to make a decision on? Absolutely not. California is a humongous state. It is well known for having the most kinds of rights in employment and things like that. You better believe there are case after case after cases that he could have considered. So why resort to this nonsense? Why pretend there's no case law? There was case law. There wasn't case law that said what you wanted it to say. And so you're coming up here and stretching stuff, and you're dragging in unpublished stuff that doesn't hold any weight whatsoever. And you're using it to take authorship of California law. You're a federal judge sitting in district court in New York, and you've just assigned a new law to the state of California. How dare you? And you used unpublished case law to do it? The hubris of this man. He makes me think of, I used to watch this because I like to watch my favorite movies over and over again when I fall asleep. And for a while, it was the movie. It's a really old one, but it's really good. It's Susan Sarandon and Tommy Lee Jones. It's The Client. It's a John Grisham movie. And in there, Tommy Lee Jones is just this cocky attorney, and I love that man. So even though he was like supposed to be like unlikably cocky, I just I just love him. I love him. He had this strong Southern accent in it, and he would go off and he would quote scripture, and he just had this like bigger than life personality, and he was going off on a tangent, and he goes, "What wanton hubris!" And I love the word wanton. I have always loved the word wanton because it's so, um, I don't know, just sometimes you need a word that just is so big in its meaning, and that's one of the ones that you need. So, like, wanton hubris is just like this out of control hubris, and that's what I feel like where he is. And I'm on a Cassidy side quest again. But, the hubris of the man who takes it upon himself to do this is just insane to me. But that's not all. So he then goes on to criticize Wayfarer for using dicta, but and we're going to talk about what dicta means. Um, and then he uses it himself and stretches it from cases that actually dealt with employers to try to label a third-party PR company as an employer in order to claim fee-hub rules were broken. Rather than use all of the many cases that are available that clearly state this and what he should do, he goes out and takes authorship of California law and creates a brand new shiny rule all of his own. Even worse, he put this order out. Isn't Blake's reply to the motion for judgment on the pleadings due today? Isn't today the day? Am I mistaken? This man has never been in a rush to do anything. Why did he put it out the day before she's due to file her MJOP? Because now she can take it and use it to rewrite whatever she had written, to try to jump on the things that he said to make theirs a stronger argument, because it's like the teacher just put the answer key, turned it around to his favorite student so that that student could get all the answers right. Oh, I just saw hubris. It's here we go. HUBRS. It goes beyond ego and conceit. It's almost like considering yourself godlike. It's like a very high or ridiculously exaggerated opinion of yourself. Oh, thank you. Yeah, I was looking for the answer because I couldn't remember. So I think maybe I had this day in my head because um everything else was due, and yeah, like you said, 2 weeks. It wasn't said otherwise. That's crazy that he didn't give her. He's gotten so many extensions, and now it's like you don't have a due date. Just turn it in whenever. Turn it in whenever, baby girl. Anyway, but he did this before she and before he's like, "I'm not doing one without the other. I'm gonna do them together." And now all of a sudden he does this. But, and I saw Omar was exceptionally optimistic last night. He did a live with Lauren, and, he seemed to think that, oh, he wasn't too concerned because he felt that, yeah, he had to do he did the MSJ, but he did it for this reason, and, um, it's on the evidence, but the MJOP is just on the legal stuff, so I'm sure he's gonna grant it. It'll all be gone. But I think he forgot one very important thing. Not long before the judge ruled on both of the dispositive motions, Michael Gottlieb came running to the court with a letter talking about a new case that had just gone down in the Second Circuit. Do you guys remember? I talked about it. A lot of us were like, this case is not the same thing at all. It was a case where not only was the motion for judgment on the pleadings file, not motion. Let me start over. Here were the differences. They filed a motion for summary judgment with almost 1,000 pages. of evidence. And then the opposing side filed an opposition to it with like 700 pages, or maybe it was opposite. I remember together it was almost 2,000 pages worth of discovery and big arguments. They did not file any type of motion to dismiss. There was no motion for judgment on the pleadings. There was no 12C. There was only a motion for summary judgment. And in passing in that motion, they said something about, oh, just considering it a motion to dismiss, whatever. They did not file the right document for that. And the judge takes these huge filings and goes, I'm just going to rule on it like a motion to dismiss. And so it got appealed. And the Second Circuit Court of Appeals said, no, you can't do this. Now, in the dicta, we're going to talk about that. You'll know very well, if you don't already know what that means, very well after today. But in the dicta, which is not the important part, it's not the decisions, he also talked about when that much discovery has already been collected. However, you can't just take that, and this was Michael Gottlieb's interpretation, is that when you've already gathered all of this discovery, that it's too late for an MJOP. It must be a summary judgment motion. That is not what that order said. That is not true. A motion for summary judgment is something that is granted by the federal government. It is a motion that is allowed to be filed. It has criteria that it cannot be too close to trial. That's it. So that is not what the ruling was about. Those were not the questions that were put before the court that day. That was not in their holding, and it was not the important part of the case, and it's not what it said. And the Second Circuit, even if that is what they said, they do not have the authority to strip away a motion that is provided by the federal government for people to use. So that was taken all wrong. And a lot of us talked about it. No, he's completely molding this around, what he wants it to say for Blake's benefit. Michael Gottlieb was. Then when Liman rules on it, he didn't use it, and he explained why he didn't use it, but he did note in his order that very thing, that erroneous statement that Michael Gottlieb had made, that when it's that far along and that much discovery has been collected, then it should be a motion for summary judgment, which was so wrong. But as always, whatever Michael Gottlieb says is law to Judge Liman. It's right up there with the federal rules. And so I remember that. So I do not share the optimism that Omar shared. I wish I could be as optimistic about it, that he did all this, but it's going to be okay because he's going to rule in their favor in the MJOP. But I remember him saying that he agreed with Michael Gottlieb's take on it, which would mean I will not be the slightest bit surprised if he just denies it and says, we're too far along in the case and you've collected too much discovery, and I'm not even going to entertain it. I mean, I won't be surprised. I'm not saying that's for sure what he's going to do, but I will not be surprised the slightest little bit that if that's what he does, because he was inclined in that way, and he said so on the order. Okay, let's see, what other notes do I have here? Additionally, this decision that he made, this has the potential to be a huge mess, a domino effect, a mess for California, a mess all around. Every order is a record. And I say this all the time. I know those of you who watch might get sick of hearing me say this kind of stuff, but every single ruling that he makes in this case does not just affect this case. in a bad way. A lot of them have affected this case in a bad way, but they have the ability to affect other cases in the future. When a judge anywhere in the Second Circuit or in the SDNY, which is the largest federal court, the largest circuit, the busiest one, um, will look at decisions he has made when it's time to make their decisions. And this could be a ridiculous mess, and we'll get into all the details of how that could happen. But when you have a federal judge making decisions about California law, when he is not super familiar with California law, it gets complicated. And I just want to say, maybe there's no case law, Lewis, because it doesn't apply like how you want it to. Stop trying to milk a bull. Stop trying to sue an astronaut for medical malpractice. Here's a novel idea. Use the law that's available to a plaintiff, like everyone else has to do. Blake had an established cause of action available to her to use against non-employer defendants like TAG. You may have heard of it. It's called defamation. She failed it. Why has this become yet another episode of Blake getting yet another dose of the now famous New York backdoor law? That's what's happening here. Don't act like the only chance she had to go after TAG was this. She had defamation, false light, things like that. They failed. They failed. Why are you disguising a backdoor defamation claim under California employment law to keep it in there for her? Why? Now, before we get to the issues that I saw and I felt were off in this case, and I do want to say these are all just my takes. I'm not sitting here telling you like this is like scripture. This comes straight out of the US Supreme Court. These are my opinions, my takes, things that I see that I don't like, things that I notice. But so don't just take it with a grain of salt. Let me take this with a bucket of salt. It's my opinion, and others I'm sure will disagree with it. But I wanted to point out this is somebody that I follow also on X, Lawyered Up. I'm just going to refer to them as a they because I honestly don't know if it's a woman or a man. I just started following them this week. Earlier this week, there was something that they posted, or maybe it was last week, that they had posted that they disagreed with Judge Liman on. And it was something that I also disagreed with him on. And I was like, yay, somebody will finally say it. And I was just absolutely thrilled. So naturally, when I saw this comment, I was really, really excited. And I want to share it with you in case you don't go on X or don't follow this this person. But they say, and they are an attorney, as far as I know. So these were their issues. So that's regarding the denial of TAG's motion for summary judgment. The judge denied TAG's MSJ, ruling that there are genuine issues of material fact regarding whether the alleged smear campaign affected Lively's prospects for career advancement. I disagree with Judge Lyman's decision here. Beautiful, beautiful words. Thank you, Lawyered Up. In my view, he is misapplying the Janowitz case, and we'll go over that a little bit, which dealt with continued adverse employment action. Also, he quoted this language from Bailey versus San Francisco District Attorney's Office. And this is the quote, adverse treatment that is reasonably likely to impair an employee's job performance or prospects for advancement in their career falls within the reach of FEHA's anti-retaliation provision. However, so this is what happened. This is what he does. This is a pattern. I've talked about this kind of stuff before. If he cannot find case law to support what he wants to say, he just doesn't put any. And if he can't find a ruling that's what he likes, he will find this dicta or these other sentences like this that are not the ruling from the case. They're just phrases from inside the case. And he will quote that as if that has some kind of authority. And so this attorney's calling him out on it. So he ignored the other more pertinent parts of the case and just like it's so much like Blake. It's cherry picking. It's cherry picking and authorship. The phrase adverse employment action does not appear in FEHA, but has become a familiar shorthand expression referring to the kind, nature, or degree of adverse action against an employee that will support a cause of action under a relevant provision of an employment discrimination statute. Let's not forget that the very most important thing is that this is employment law. FEHA is all about employment. So trying to make other things stick to it is just foolishness. I mean, what's next? When something doesn't fit here, is he going to go start digging into bankruptcy law to find a phrase he likes and say this makes it work? Given the above definition of adverse employment action, the judge should have inquired whether the alleged smear campaign would have supported a cause of action for employment discrimination under California law. The answer to that question would be no, because Lively was no longer an employee when the campaign happened, and this was not a case of continued adverse employment action. Okay, so that's only half of the tweet, but we're going to break down some of the stuff that was said in this tweet because the second half of it talks about something else. So I wanted to divide it up and go over the issues that they have found. So I am in complete agreement with this about this Janowitz. So as I said, FEHA, and as you guys all know, we've heard enough about it that we know, this is all about employment and protections in your employment. And if you remember correctly, Title VII was the federal law that the judge ruled that Blake didn't meet because she, well, in part, not only because I know people love to say, oh, it was all a technicality. It also didn't rise to the level, and the judge did put that in his order. But secondly, she was not an employee. She was an independent contractor. And so she did not fall under Title VII. But as little girl attorney, who is a California attorney, stated that FEHA is for both. It can be for an employee. It can be for an independent contractor. So that portion of it is not important anymore. It doesn't matter. It does not exclude Blake's claim. This doesn't kill her claim. However, it's been expanded beyond its established employment context. So in Janowitz, which is one of the cases that this attorney says Liman misapplied, and these are the arguments that Kevin Fritz tried to make. He said these cases, everything happened inside the workplace. So there is no question. We don't even have to know if they were employees or independent contractors. All we have to know is that everything in the complaint happened inside the workplace while the employee was still working there. You cannot compare that with this woman who was no longer even working for the company and claims that all of these things happened long afterwards. She wasn't working for them anymore for months. She was done. And it's so funny to me how precise Lyman got about her 6 consecutive weeks of filming and how imprecise he is on this. He had her free and clear of her contract because in his faulty idea, a strike could come along and disrupted her 6 consecutive weeks. And so she was miss free and clear, didn't owe anybody anything anymore because the strike had messed up. Forget the fact that strikes don't count. They don't help you to no longer be under a contract. Not only that, that's not what disrupted her filming. The writer strike happened then, but that had nothing to do with her. The SAG-AFTRA strike happened the following month when her 6 weeks would have been long done. She got on a plane and flew to England to be with her husband, where he did not let her put on the lady pool costume and actually play lady pool. He just allowed her to do the voice. But anyway, which is much crueler. Here was Justin telling her, "You're okay, you're fine, don't even worry about it. We'll work around it, we'll show my body more. We'll angle the camera, you've got a body double." And here's her husband like, "You ain't putting that thing on. I'm getting this hotter chick over here." Now that's a Cassidy side quest. Let me get back to where I was. But that's what broke it up. So here he was nitpicking so into every little detail, making up stuff, getting facts wrong, but still packing every little possible excuse he could to exclude her from her contract. But now here, it's like, oh, it doesn't matter that it doesn't say that. It's good enough. Ooh, the people who defend this man drive me crazy. Like, oh, he's so procedural. He's procedural when he wants to be. And I talk a lot about how I feel about that in that 17 questions with Bocce. And hopefully we'll get that worked out. She actually just emailed me. I saw it pop up on my screen about that. I'm going to actually respond to her real quick. Sorry, guys. Guys, I'm so sorry to do that, but we have a lot of editing to do on the interview, and I don't want to make her wait because I know she wants to keep this on a timetable, and she has her next person she's trying to line things up for. So I wanted to answer. Hey, Kay Bella, I need to get a drink and join Cassidy on her beach. Absolutely, we all do. We need to have a big old drinking beach party. After all this, oh my goodness. It upset somebody, I forgot who. They said that they couldn't take the up and down anymore and they were going to take a break from the case. They just couldn't take it. And I understand that. I've done that a few times myself. But so 2, the actions were all already established workplace retaliation. Criticism, hostility, and pressure from supervisors. That is normal workplace retaliation. There's no question about the Janowitz case because it fits the criteria that's set forth not by federal rules and not by federal district court judges, but by the California Constitution and how California chooses to enforce their own laws and statutes. And this case met that criteria. And you don't get to just come in here and change it to suit someone in your court. 3, the case concerned continuing employment retaliation. Another difference, this was something that started during the actual employment and then continued beyond it. So it's not the same thing. It's not something that happened well after, or as alleged, sorry, because I don't believe that it happened, but was alleged to have happened well after the end of the employment. So another big difference. These things matter. These things matter a lot. Number 4, that it kind of reviews what I just said. I got a little ahead of myself, sorry. Blake's case is a post-project external reputational campaign, that's a tongue twister, against someone no longer in a traditional employment setting. All of these things are outside of those other standards in FEHA. 5, California courts interpret the statute broadly, but have consistently done so within the framework of actions sufficiently connected with the employment relationship. You know how we know that? Because none of Blake's attorneys, and not even her bonus attorney, Judge Lyman, were able to come up with a single case to support their arguments. If there was such, we would have seen it. There was not. So all of the other cases that have actually taken place have been within that employment relationship or that employment frame. And 6, he extended Janowitz far beyond its facts and doctrinal limits. So that kind of repeats the title, but I just wanted to say it again another way, because leading into this one, this is called doctrinal expansion. It untethers the statute from its employment law foundations and transforms it into a generalized remedy for reputational injury affecting future opportunities. Do you guys remember? Oh, I want to get it straight in my head. It was with the Friends case. And they kept quoting about the law that governs that. And they wanted to make it clear that it was not meant to be like this list of rules for all employers to have to follow. People in this country tend to want a certain kind of independence and a certain kind of freedom to decide these things. They don't want, and the government has always refrained from sitting down and imposing a very strict list of rules to follow. And so they were very, very careful to say that while we have this law was not intended ever to be that sort of thing, and we are not trying to turn it into that sort of thing. Well, this is that sort of thing. You're taking something that's meant for one thing and trying to transform it into something that's generalized. And this, we're starting to get into a hint of what the possible damage could be from doing that. When you start opening up laws like this, it can lead to all sorts of crazy places. Number 2, California law does not support this expansion. And that's all that matters, because you're not just talking about a district court who is following a choice of law. We've seen situations where Lyman has said, when he's considering in his rulings, when he's considering choice of law, and he will say, well, California law says this and New York law says that, and so we're gonna blah blah blah. And that's, he does have freedom to do that in those situations. There's nothing wrong with him doing that. This is not that. This is him interpreting FEHA. He cannot change that. That's not a choice. He can't say a little bit of this, a little bit of that. That's not, it's a completely different situation. If there is nothing in California law that tells him this is okay, it's because it's not okay. They will expand their own laws when they feel that they need expanded. It is not up to a federal judge sitting in New York to do this. Number 3, Janowitz must be read in context, not abstracted, or shall we say cherry-picked, into a stand-alone rule authorizing liability whenever a plaintiff alleges harm to career prospects. So why he quoted Janowitz is because it was its own expansion. It did expand something. It didn't expand all the things that he's trying to expand it to, but it went beyond just like, mostly when you think of, retaliation or workplace, um, abuse, it has to do with, like, you get demoted or you lose some of your salary or you lose some of your benefits, or you get maybe not even demoted, but just moved to a different workplace area that's not as nice as the previous one, or maybe your duties will change a little bit. Even if your pay and your title stays the same, maybe you start getting unpleasant stuff. Like one of the cases that had come up before, there was a woman who used to drive a forklift, and she did file a harassment lawsuit, and then she was taken off of the forklift and had to do like the walk around yard work, which was much more physical and much more difficult. That is outright blatant retaliation. But this case, Janowitz, what that added is this career prospects. So not just your now, but what you can do in the future. And so that was the importance of this case, but it didn't open up everything else. And that's to say, why does Judge Lyman feel that it's why did he just take for granted that it's true that Wayfarer caused harm to her career prospects? Did he look at her movie making history? Did he look at how much money her hair company was or could possibly make? How much her beverage company was about to die the year before? They wanted to shut it down because it wasn't making enough money. Did he not consider any of that stuff and just say, "Oh, okay, well, Michael Gottlieb or Ezra or the two together say that this harmed her career prospects. So we're just gonna say, yeah, it's true." And on a motion filed by the defendants where he's supposed to take their word, he's like taking Blake's word and saying, yeah, it did harm her future career prospects, so it fits. Number 4, his contrary interpretation impermissibly enlarged FIHA's reach without clear authority from California courts. And we're going to talk about how, when you are bold enough to do something like this, or when you honestly find yourself in a position where there is no case law, it is a novel case, it is something altogether new that the court has never heard, there is something that you can do about that. And they did not. He does not speak of any kind of communication with California courts, nothing. This is his own personal decision. And I do want to add that we heard some really brilliant California attorneys that speak on this case. Little girl attorney, we heard her excitedly talking about how brilliant Kevin Fritz's motion was. And she explained FIHA. This woman understands FIHA. This is not only her state, this is her field of expertise. She knows, if anyone knows, she knows. And she knows better than Lyman. And I haven't gotten a chance to listen, but I kind of checked throughout the day and hadn't seen anything posted by her when I looked. And then I was busy trying to finish this up. But I saw when I first logged on, someone had said in comments that she did finally go live and she's confused by it. So I'm happy to hear that it's not just a few of us being thrown, and that it is this California attorney who specializes in this field being thrown by it. We also heard, if you watched Ron Zambrano, he's sometimes on Zach Peters, and he's also on Popcorn Planet's channel, and he seemed excited about it too, and he explained it in depth. That's one of the longest times that he's spent being interviewed on the channel, and both of them I felt like really explained this well, and the meaning behind all of the motion, and they seemed to think that it was beautifully and brilliantly written and that it would be granted. So to me, it's very confusing that it was not that it was denied and denied in like this. I don't know. It felt like an angry. I don't know. I felt like he was mad at them because they didn't take what he said. They didn't just go with it. Let me see. I'm sorry. I'm just looking through my notes real quick to make sure I didn't miss anything. And yeah, coming back again to this idea that you can criticize Wayfarer if you want to, but I don't believe there was anything they possibly could have filed that would have pleased him or made him change his mind. I think his mind was well and truly already made up. And what were they supposed to say? When it comes to the number, there we I was talking about it with Bachi last night and she went through and looked some stuff up. And they have over 5 employees, or at least they did before. So the number wouldn't have changed anything. What were they supposed to do? Just play along with what he said? They didn't feel that what he said about the law was correct. Were they supposed to just buy into his version and like the emperor's new clothes, play along with it? Forget about the accurate application of FEHA and California law? No, they wanted to clarify their standing that this is not a FEHA claim. And so that's what they did. And you can't criticize them for it because that's what they had to work with. That's all they had to work with. And they were, in my opinion, right, and in several other people's opinions. Let me see. Okay. But again, the Yanowitz case, um, he cherry picked just what he wanted from that and ignored stuff that went against actually what he was trying to do with this order. So sorry guys. So the cases that were quoted do not authorize FEHA claims based on independent post-employment media campaigns disconnected from personal management. In both of the cases, and I already talked about this when I went over Kevin Fritz's letter or his motion, sorry, that those cases were truly employment. It was people, they were third parties, some of them, but they were hired to do employment HR type things like hiring, training, that kind of stuff. Everything they did was, you couldn't deny, you couldn't say that it was completely detached from employment because everything they were doing had to do with that. They just happened to be third parties. That is not the situation in this case. He took a rule about workplace behavior and applied it to something that is alleged to have happened outside the workplace. That distinction matters. A teacher can tell her kids not to chew gum in class, but that teacher can't stop them from chewing it once they leave the school. A company can say, you have to wear a uniform while you're at work, but they can't tell you what to wear when you're off duty. Walmart doesn't get to come in and change the rules in Target. You can't just grab other things and drag them into situations where they don't apply. And here is where we start talking about the damage. I've gone ahead in my slide before I was supposed to. Where does it end? So never before has a PR company been called in under employment law until now. And now it's done. And there are already, if you Google it, because I was Googling when I was doing research, has there ever been a case where a PR company was brought in under employment law? And the first word I saw in the answer was yes. And the case that came up and I click on was this case because this is the only one. But it's already out there is what I'm saying. There are already not only like newspaper articles and tabloid type articles, there was an attorney who wrote an official legal paper on it already. So that's why I always say it doesn't just affect this case, it becomes a record, it becomes distributed, it becomes used by other judges. But what's next? So we have a PR company who has nothing to do with employment law. What if the landscapers are there and Wayfarer starts talking to their hired third-party agents who were there to mow the lawn, and they're like, "Oh, you know what? This Blake is just so awful." And he goes home and tells his wife, and his wife gets on and does a post about Blake Lively. Can the landscaping company get called in now too? Because according to Blake, that's retaliation egged on by Wayfarer. What about a plumber who showed up to unclog the toilets? Maybe he's busy on Reddit. He goes home and posts about it on Reddit because of something Wayfarer said to him. Does he fit under FIHA now? What the heck? It's crazy. You can't open up a can of worms like this. Okay, now we get to this one. So I made this a long time ago when I talked about 47.1, and then I've referred back to it a few different times because what my point was with 47.1 is how federal courts often see things like anti-SLAPP. Even though 47.1 does not consider itself anti-SLAPP, and it made changes, I think, probably to keep it from being labeled as anti-SLAPP, but it still did have some of the features that could create a situation. What we have are two distinct and separate branches of court systems. The only thing that they have in common is that they both operate under the Constitution. But from there, it completely separates to the federal branch and the state branch, and every state has its own. So every state also has their own constitution, their own statutes, their own laws. And they have their own state Supreme Court, with the exception of New York, who for some unknown reason has their lower courts called Supreme Courts, and then they have to label their higher court. I forgot, I can't remember what they call it. The New York Appellate Court, New York Court of Appeals. I don't remember, but most states operate under this to the right. You have the lower courts, and now I'm excluding like military courts and bankruptcy courts and family court and things like that. But you have the state level, and then you have the state appellate, and then the next one above it is not a court, it is the state constitution and statutes, and then you have the highest court would be the state Supreme Court. The federal branch, the highest court is the U.S. Supreme Court, and it comes up with federal statutes instead of state statutes. It does not have its own constitution. It's the U.S. Constitution, but it's enacted by Congress. Underneath that is the U.S. Court of Appeals, and then you have the federal district courts. And this is where Judge Liman is. He's at the lowest federal court level. Now, federal courts do apply state law, like we've seen here, because the federal rules do not have the entire code of laws like the states have. So there's a choice of law discussion usually, and if there's like a jurisdictional thing like we have here, we have people from multiple states asking for different state law to be applied. If it's just in a federal court in that state and everybody's from that state, they just use that state's laws. So we have this situation because there are people from different states going. So a federal court has to apply a state's law at some point. But a state court never has to apply federal decisions. They can choose to use as persuasive authority. It is not binding. Like if they're in every state's constitution and their rules, their statutes follow pretty closely the federal rules. Sometimes it's even like word for word verbatim. And then other times it's different. But in some cases where they haven't had like maybe an obscure kind of case, they haven't had a lot, because we're talking about a small group. We're talking about just a little state. Think of Rhode Island, such a tiny little state. So maybe they have not in their court system come across every type of case they possibly could. Well, they can choose to look at how federal courts have applied a certain statute, and then they can use that to help them to apply it in their state. But they're not obligated to. The only time they're obligated is if it is a constitutional question, something that is the federal law, and then they have to defer to the Supreme Court. So sorry, I spent a little too much time. I get really in law nerded out by this kind of stuff and get real excited. But anyway, all of this to say, what was it to say? Federal district courts uphold laws of the states to make decisions, but they are not higher than state courts. Their decisions are not binding on state courts. These are two very separate and distinct systems. But the federal court is a judiciary. It is not legislative. In other words, they don't make new laws. That's for legislative bodies, not for them. They apply existing laws. So this overreach by Judge Liman, in my opinion, is kind of outrageous because he does not have authority over the state of California's statutes. And this is an old, long-held thing. And when I went through the 47.1 and made that chart, this case, Erie, was a big part of it because Erie changed a lot of things. There was a lot of forum shopping where people would decide if they wanted to go into district court or state court, depending on which would be a more favorable outcome for them. There was also, states weren't so linked to each other before, and that affected even the district courts. Like the state courts, it doesn't matter if you're not linked, but the district courts are supposed to be united. And so they really needed some unifying thing to tether everything together. And so this Erie case was a U.S. Supreme Court case that kind of did that. It accomplished that. And then there were a few others that came and added to it and gave it better strength and better clarity. But when you refer to Erie, that's what it's talking about. And after that happened, it did balance things out. And it decided what the federal court rules over in a case and what state law comes in to do. So even though Judge Liman is applying some state's law as his choice of law to decide certain things, he is following federal rules for timing of motions, all of the, what is the word? There's substantive and it's completely gone from my head right now. I'm sorry, guys. I'm so tired. But it divided all of that. Like, okay, this is for the federal court to decide, and this is what you need state law for. And so it is kind of like it says here, a federal court's North Star, and one constitutionally mandated by Erie is to discern as best as it can the content of state law as the highest court of the state would view it today. So when they're deciding something, they use the highest court, which would be the state's Supreme Court. The task of determining state law without definitive authority, because Judge Liman made a big deal about, well, there's no well-established rules on this. So if that's the situation, there isn't definitive authority from that state's highest court. What they call it, and this is, as it says, irreverently dubbed the Erie guess, because the task is challenging. And as even some federal judges have admitted, federal courts have not been adept at it. So what it means is they study case law, they see what's happened, and they make an educated guess that they call the Erie guess, taking all those things in consideration that Erie set up to decide what they think that state would decide. And that's what they should go for. I don't know, guys. Does it feel like that's what he did at all? He's like, oh, there's no there's no case law for this. So I'm just gonna make my own. He paid no respect or deference to California law, which he should have. You're supposed to. Now here's the danger. Wrong Erie guesses can have a grave impact on the principled and orderly growth of state law principles. Even when the federal court guesses right, it unavoidably puts its thumb on the scale by influencing the subsequent state high court decision it predicted. So it's still it's butting in where you don't belong. It really is. And in this case, well, I'm not going to get ahead of myself. That comes in a moment. So this really intrigued me. So this was one of my rabbit holes. I don't know a lot about California law, so I really wanted to do a lot of research on it. And I found this article, which was really, really interesting. It's from, I don't know if it's just a website or if it's an actual magazine. It's called Above the Law. This was the first time I heard of it. But the title of the article was Ninth Circuit Trends in Certifying State Law Questions. So certifying, that had come up in a Tennessee case I talked about before that you may or may not have heard me talk about what certifying is. So that's what I was actually searching in the Ninth Circuit. And lo and behold, there it was, an article written specifically about the Ninth Circuit, which is where California resides, and about certifying state law questions. So what is certifying? This term, the U.S. Supreme Court highlighted the importance of federal courts certifying novel, which is just another word for new, a case that has not been tried in a court before, determinative issues of state law in federal appeals. So this deals, it's speaking specifically about federal appeals, but we can apply the principles of this beyond that. And this certifying is available to district courts. They have a right to do this, but they're not required to do it. And maybe they should be, rather than deciding those issues themselves. So what it is they say, okay, I'm trying to rule on this case. This case is a part of your state law that I am not too familiar with, and I cannot find, it's a novel case. I cannot find a case that you have ruled on to base my decision on, and I don't want to make the wrong decision. So could you please look at this case and tell me what you, as the deciders of your own state's law, would decide in this case? Now, a lot of time, the appellate courts will do this much more often. They're on a not such a pressing schedule to get a case done. But a district court is a lot less likely to do this because like this case, for example, if he would have sent this to California and asked them, then he's kind of got to halt the case until they come back. Now, he could have done it in all that time that he gave Blake extra time and waited and waited and waited before he considered the motion for summary judgment or the motion for judgment on the pleadings. I'm sure in all of those months' time, he could have gotten a reply back, but he didn't. Instead, he wrote new California law. Let me go back because I did miss a lot in my notes. So it feels like to me, this is another opinion thing, that instead of finding case law to tell him how he should rule, he decided he wanted retaliation left in and found a way to try to force it in. He has no law to support this decision. It has literally never been done. So instead of coming to the logical conclusion that everyone else does and saying the only time FEHA has been applied this way is with employers or third parties who performed employer duties, he comes along and decides to say, I want it to fit, so I'm going to make it fit. And I hope with all of my heart that he gets a humiliating appeal overturn for doing this, or gets a tongue lashing from California Supreme Court for taking liberties with their laws in a place that could affect future cases that would do the same. That's what he hasn't thought of, the domino effect of his decision. Just like he didn't think about the domino effect that could happen when he allowed the content creator subpoenas. Now that lays open. He never quashed our subpoenas. He let her withdraw them and then ruled that they were moot. And now because of that, other people can come along and do the exact same thing. They can send it out to content creators. It is such a dangerous thing to do. And that people will lose their First Amendment rights and maybe not even know it, because maybe they made their Instagram account, I don't know, 20 years ago when they were 14. And they don't have that email anymore. They don't check that email anymore. Never get the email that their information has been subpoenaed. Well, thanks to Judge Liman, that can happen. And who knows? Maybe it's a worse situation than Blake trying to get our information. Maybe it's a woman who's hiding from a dangerous ex in fear for her life. There's just so many things that could happen from these decisions that they have to consider what they're opening up when they go beyond and stretch things beyond what they're meant to cover. This same man who won't stand up to Blake and say, no, you can't do this, this is beyond the pale, is the same man who angrily refused to allow an in-camera hearing to see whether Stephanie Jones and her security team were involved in criminal activity. But he sure was willing, not once, but twice, to pierce attorney-client privilege and allow messages between these defendants and their attorneys and hand it over to Blake and ultimately end up on the docket. One of the most sacred privileges we have is attorney-client privilege, and he opened that up twice. The same man who forced Natasha Heath, an unrepresented non-party, to hand over her most sacred moments, giving birth to her child, to the Blake camp. He stomped all over her rights. He violated her. He victimized her. So oh no, I already said this part about they can avail of themselves to this certification, but it's not binding. And when they do these eerie guesses, they're much more open to appellate scrutiny, very much more likely to get overturned in appeals because they're making a guess. And no, I'm trying to get ahead of myself again. Okay, so it's continuing with this same. Okay, yeah, the same article. This is where I wrote in the notes the wanton hubris. And what's sick about this is that this isn't just any old California law. This is their civil law. This is their FIHA. This is what they have decided to put up to protect their citizens. And this is what he dares to mess with. But they say okay, so I skipped down to just the more important parts of this article to save time, but it named a US Supreme Court case, and that's what it's discussing because it is this Supreme Court case that they're saying is going to change things. So the court observed that the Louisiana Supreme Court rules allowed federal courts of appeals to seek guidance on novel issues of state law and concluded that the Fifth Circuit should have done so in this case for two reasons. So they're saying not only you had this available, but you should have used it. You should have sought guidance instead of trying to do this on your own. 1. The dispute presented novel issues of state law, peculiarly calling for the exercise of judgment by the state courts. It is exactly the same thing in this situation. It's an issue he, by his own admittance, has never been decided or determined or ruled upon in that court. And because it's FIHA, it would call upon the state to make this decision. So according to this, what the Supreme Court ruling was, is that he didn't and should have. Now, like I said, this is talking about appellate courts, so it's not specifically saying district courts, but the principle behind it still applies. 2, certification would ensure that any conflict between state law and the First Amendment was not purely hypothetical. The court ruled that the Fifth Circuit should not have ventured into so uncertain an area of tort law, one laden with value judgments and fraught with implications for First Amendment rights. Well, we don't have that in this case, without first seeking guidance on potentially controlling Louisiana law from the Louisiana Supreme Court. So all of these principles, can we not see how that should have been applied and how he should have taken this theory to heart? It goes on. The Supreme Court's endorsement of the certification procedure in cases where novel issues of state law, particularly those involving cutting-edge moral or policy issues, we're talking about civil rights here, the protection of their citizens. That's definitely a morality thing. Is it policy? Perhaps. Are at stake further underscores the importance of certification procedures in the federal courts of appeals. In the June 4th, 2021 Law 360 article, when your Ninth Circuit case needs California High Court input, and this is so interesting, this part, we documented the increased use of the certification procedure outside the Ninth Circuit? No, by the Ninth Circuit with regard to the California Supreme Court. So we're talking about the circuit in which California resides. They even are increasing the use of certification in their rulings, and they're the circuit that California lies under. But why? So, and this is even more interesting. Let me look at my notes real quick. Okay, yeah, let me read these from my notes first before I talk about this chart or graph. States often have similar laws because they're all based on the US Constitution. A lot of state laws are word for word taken from the corresponding federal laws, but one thing we know about California is that they are a state with possibly the most unique set of state laws. There's something they call regulatory red tape. As of 2023, the California Code of Regulations contained over 420,000, almost 500,000 individual restrictions. For comparison, the second most regulated is New York, and they have roughly 300,000. So not only are they the highest, but they're 120,000 higher than the one directly beneath them, which has a lot of laws too. They call it the California effect. Because California's economy is so massive, its unique standards, especially for auto emissions and consumer privacy, they're the birthplace of the Silicon Valley. They've got so much that comes out of them that they become de facto national or even global standards. In several categories, California laws go far beyond federal requirements, things like labor laws. The state has some of the nation's strictest overtime rules, mandatory paid sick leave, and among the highest state level minimum wages. And then it talks about some of their other things like the emissions and gun safety and stuff like that. But the point is that California is not like any other state. It has I mean, I'm sure the judges struggle to keep up with it. I'm sure the attorneys struggle to keep up with it. And so the Ninth Circuit, who has who has to decide the appeals that come to them from California, they're like, we're not even going to do this ourselves. We need your help, California, because we don't know all of your laws. There's too many. But here we have Liman, who sits, he's not even in an appellate court in their circuit. He's the lowest level federal court in New York that has 120,000 less regulations. This man is not familiar enough with this state's laws to confidently make a ruling like this. Because once you make a ruling about something that's in FIHA, again, domino effect. How many things attached to that could it possibly affect? And once you start doing it in New York in your district court, other courts can do it too. They can follow your example and things can get really stupendously crazy. So my big question is, if the Ninth Circuit appellate justices, are they called justices there? Not every state does that. I'm not sure. Most of the time, the state's Supreme Court calls themselves justices. I know New York doesn't. It's so backwards. The low-level courts are justices and the high ones are judges. It's so weird. Only New York does this weird stuff. But they're like, yeah, you're in our circuit, but you guys need to have your own rulings because only you guys know what's going on over there. And we see that reflected right here. It says the most notable finding from our study of Ninth Circuit certifications to the California Supreme Court, however, is that only 11 of the 47 cases that asked for this certification were issued by a party. The overwhelming number of certifications were done by the circuit sua sponte. And if you don't remember sua sponte, that means that the court on their own, they're not being asked by a party to do this. They just decide that they're going to do it. We saw Judge Liman, that's what he did to jump to the saving of Taylor Swift when she got subpoenaed. And Blake's attorney, I think it was Ezra, if I'm not mistaken, but it could have been Gottlieb, but I feel like it was Ezra, filed a nasty letter on his docket. Wayfarer was dealing with it in the right jurisdiction in Washington, D.C., but Ezra had to get it on the docket in New York so that everybody could see it. So she files there. And Brian Friedman responded to her on the New York docket. And without being asked, he jumped up, sua sponte, struck it from the record. Left hers. Hers is still sitting on there. If you go look right now, it's still there. But only Brian Friedman's didn't belong there. And part of his reasoning for getting it out of there was that it doesn't belong on this docket. It belongs in DC. So why didn't you get rid of hers? Hers didn't belong there either. But anyway, Cassidy side quest. That is sua sponte. The judge is getting up, not without being asked, and saying, we're going to do this. So that's kind of crazy. Of the 47 cases, only 11 were not the actual courts saying, we need your help, California. I mean, look at the graph. And it divides it up by like timing, like after oral argument or after briefing. And then, but in every case, well, the last one looks pretty much tied across the board. But in the first two cases, the green is the sua sponte cases. So it's a big deal. You don't want to just go and mess with someone else's law. You should have pause. You should ask for this certification help, in my opinion. But good old Lewis, he don't have a problem with it. Not at all. Sorry, guys. Just looking and got my pages kind of backwards, I think. Yeah, here we go. And now this is what he could possibly face. I don't know how, because it would be appealed in New York. Perhaps the court, the appellate court in New York, if it gets appealed, perhaps they would do this, then reach out so that they don't make the same mistake and it goes up higher. But once the panel members conferenced after oral argument, they all agreed that the state law issues in the case were not clearly resolved by existing law and would benefit from input by the relevant state Supreme Court. Where counsel have a Ninth Circuit appeal involving novel state law issues, they should be prepared for the possibility of certification. That's how often it's happening. They're like, be ready, it could happen. With the U.S. Supreme Court highlighting the helpfulness of using state court certification procedures, the number of certified state law issues in the Ninth Circuit is only likely to increase. Now, that is the opposite of wanton hubris. That is a group of appellate court justices that say, or Supreme Court justice, that wouldn't be Supreme Court. So the appellate court judges saying, we recognize our limits. We humbly defer to you. And that's what Liman is lacking. That's why he didn't recuse himself from 13 different cases that he well knew that he should. That is hubris. Sitting in New York and writing a new law for California, that is hubris. And this here is the opposite of that. These guys going, we don't want to make a decision on something we're not familiar with. Please, we defer to you. That's people who really care about justice. Okay, now we're back to the rest of that tweet. So they continue, the language the judge quoted from Bailey was not the holding in that case. And we're going to deep dive what that all means. It has to do with dicta and that. The case held that an isolated act of harassment is actionable if it is sufficiently severe under the totality of the circumstances, and that a coworker's use of an unambiguous racial epithet, such as the N-word, may be found to suffice. And this case has come up multiple times throughout this court because Blake's team has tried to say they have stretched this, which is a completely different situation. This is something absolutely repugnant, hateful, and no question about the malice behind someone saying this. But they have said, oh yeah, it doesn't have to be that many that severe or that many instances, and they've tried to apply this case to that. So this case has been floating around, this case has been floating around, the Wayfarer case, all this time. But it says, how can you use a language in a case that doesn't involve post-employment retaliation to justify a ruling that post-employment retaliation is actionable under California law? And you read this and you're like, how did Liman not get this? And Kevin spelled it out so well. And Kevin's a New York attorney, but a big part of the Wayfarer team are California attorneys, and you better believe they help each other out. They confer when they're writing these things. This is puzzling because no California case has held that post-employment retaliation, distinct from continuing retaliation, is actionable. So they found yet another thing that I hadn't found. Not only was there no case law about a PR thing, but there was no case that was post-employment. Why? Because FEHA is employment law. If it's post-employment, you have other types of causes of action at your disposal. You're not just left without a case, you're left without an employment case because it's not an employment case. Go pursue the correct cause of action. But that's not what Liman concluded. He's like, I'm gonna make this fit. It's crazy. I needed to get a clip of Tommy Lee Jones saying wanton hubris and just play it every time I talk about something he did that was so awful. So here's another this that where he went wrong, and this is one of the ones we shared our thoughts on. Misapplied California precedent by relying on non-holding language from unrelated authorities. So that is the epitome of cherry picking. This is the professional way to refer to cherry picking right here. By grabbing this non-holding, and now we're going to deep dive what does that all entail, not just what it means, but what does it entail. So courts are supposed to rely most heavily on actual holdings, not side comments. And this is we're talking about binding authority, so this is like appellate rulings in the higher courts specifically, because those are the cases that he did try to look at from California, things that were ruled on by the California Supreme Court. Okay, this is a novel or new legal theory that California has not decided for their own state law. But I keep coming back to, is it that it's never come up, that they've never decided it, or is it this is simply where it doesn't belong? If you say, oh, I went through FEHA and I couldn't find anything about bankruptcy, is that a strange finding or is it an expected finding? Because bankruptcy has nothing to do with it. So is it a novel legal theory or does it just simply not belong there? So instead of coming to the conclusion that perhaps it doesn't belong here and that's why it doesn't exist here, he instead used a side comment, which is another word, which is a dicta, to create this new legal theory outside his jurisdiction. This is an overreach. 3, Bailey, that's the other case he quoted from, primarily addressed harassment standards, including whether a single severe incident may be actionable. The career prospects discussion was explanatory, not the operative rule resolving the case. So not everything that's in an order. Think about his order about the summary judgment motion. What was it, like 150 something pages? And the one where he dismissed Ryan, 130 something pages? Something like that. I don't remember exactly. So not every sentence in that order is what you take to prove future cases. You focus on the questions that are being answered. And well, I'm going to get to that. Hold on. Number 4, the court elevated non-holding language into a substantive rule extending FEHA beyond its established employment framework. So what do I mean by that? Going back to this tweet, the judge discounts the case provided by TAG, namely Radence versus American Association of Physician Specialists, Inc. I think it's specialists, by saying that the language, so he looks at this and he's like, oh, I'm not using that case because you used dicta. Or oh no, wait, yeah, you quoted dicta. You didn't use the holding. Keep this in mind. So he says they quoted FEHA prohibits employers from aiding and abetting third parties, not the other way around. This was something that they had used from the case. And he's like, oh, but that's dicta. However, the judge used language in Bailey regarding prospects for advancement in their career, which is dicta, in order to justify the denial of the motion for summary judgment. So it's another situation. So how many things does he have in common with Blake now? I just listed, what was it, 3 of them? Now we can add this. Her famous rules for thee and not for me. Why are you using dicta? Oh, okay, I'm ruling out your case based on this dicta. You just want to pound the table. Like, what is this insanity? So here's dicta. It's something that's said in passing in the order. It's a comment, it's a suggestion, it's an observation. It can be discussions of hypotheticals. It can talk about other cases. It can talk about laws. It can even condemn other opinions. It is not binding. It doesn't hold power. So here sorry guys, I just want to check, make sure I didn't miss. Something, because I get carried away and go several pages without looking at my notes, and I don't want to miss them. Okay. This is a really cool website, Law School Toolbox. And they explain things in very simple, easy to understand ways. And they review it, and I just really like it. So their description of what is a holding. The holding of a court is what was actually decided, including any legal rules that were necessary for the decision. The holding is the portion of the opinion that has precedential value, meaning it becomes binding on lower courts within the same jurisdiction. Here are the characteristics. So when you're looking at an order, to help you sort out, is this holding or is this dicta? So holding directly answers the legal question presented in the case. And we're going to look at what that means. Necessary to the resolution of the dispute. It creates binding precedent, and it applies to the specific facts before the court. So not every single line, like I said, is that. They give a better definition, I think, of dicta. So it starts off with something said in passing that aren't essential to the decision. They're not binding. Judges often use dicta to explore hypothetical scenarios, to comment on legal trends, to suggest how a law might develop in the future, to provide context or background information, or to signal how they might rule in future cases. Key characteristics of dicta: it is not necessary to resolve the specific dispute that's before the court. It can be a side quest, if you will. It often deals with hypothetical situations or facts that are not present in the case. It does not create binding precedent. It can be persuasive, but isn't mandatory. So a court can look at it and decide whether or not they want to use it. Why does the distinction matter? When lawyers argue that a case controls the outcome of their dispute, they're referring to the holding, not the dicta. That is the precedential value. Legal advocacy. When arguing a case, lawyers strategically characterize language from previous cases as either holding if it helps their position or dicta if it hurts. You'll need to master this distinction to be an effective advocate. And because this website is aimed at law students, it also relates a lot to law school. On law school exams, if you cite dicta as if it were binding precedent, you'll likely lose points. So, Lewis, if you handed this in, if you promoted this type of decision making in law school, you would lose points for what you just did. What does that tell you? And then the court application, judicial decision making. Judges must follow holdings from higher courts in their jurisdiction, but they have the freedom to disagree with dicta. Knowing the difference helps you predict how courts might rule, unless, of course, you're in Judge Liman's court, where he will do, depending on whose side he's trying to support. The necessity test. This is still trying to determine how they're different. Was the legal conclusion necessary to reach the court's decision? If you can remove the statement and the outcome would remain the same, it's probably dicta. Specific facts before the court addresses the specific facts before the court or speaks to hypothetical scenarios. Statements about hypotheticals are usually dicta. The language, the deliberateness test, the language, and we're going to see this in a second, of how the courts introduce what they're saying. Language like, we hold that, you know that that's holding. Our ruling is, it signals this is the important part. But something like, we note that, or it may be that, is often dicta or non-holding. And then also, the holdings are interpreted very narrowly, and the holding should be limited to what was absolutely necessary to decide the case on its specific facts. So looking at this Janowitz case that he misquoted from. So this was a regional sales manager, and she worked for L'Oreal. She was told by her male supervisor to fire a female sales associate because he didn't think she was hot enough. Well, she didn't do it. Because she wouldn't do it, she was retaliated against. The treatment became increasingly hostile. It undermined her relationship with the employees that she supervised, and it caused her severe emotional distress, so much so that she had to leave her position. Sorry, got to look at my notes to make sure. Okay, yeah, nothing on here, so I can go on. Now, in this case, it talks about the section of FEHA that was involved, that this section makes it unlawful employment practice for an employer to discharge, expel, or otherwise discriminate against any person because the person has opposed any practices that are forbidden under this part, or because the person has filed a complaint, testified, or assisted in any proceeding under this part. What do you know? It's talking about something that did fall under FEHA, unquestionably. Now, if you look at this, they're going to tell you at the beginning of every appellate decision, at the very beginning, They're going to tell you the facts of the case that they're going to decide in this appeal. So from the first page, you know what this is going to be about. And that's what they've done here. First, so quoting this case, if you're quoting this case and you're not talking about these things, you're talking about dicta, because these are the holdings right here. First, we must decide whether an employee's refusal to follow a supervisor's order that the employee reasonably believes to be discriminatory constitutes protected activity. So that's what this case was for. And if you're going to cite this case, this is why you need to cite it. Not to make something fit that has nothing to do with this point or the second point, which is we must decide how the term adverse employment action should be defined for purposes of a retaliation claim under the 440 FEHA. Look, again, you could put it right up there, which FEHA it's under all of the conduct, and whether in evaluating whether or not an employee was subjected to an adverse employment action under the appropriate standard. Each individual sanction or punitive measure to which the employee was subjected must be evaluated separately. I can skip the rest of that, but you get the point here. This is what it's talking about. This is the holding. Now, everything else in this that is not referring to these 2 points is dicta. It is non-holding. So the things that sorry, I saw my name in the chat. It distracted me. The things that are not pertaining to this are what he quoted to try to make this fit. But they're not, they have no precedential value. They have no power. They do not have the power that he granted them to do. And now we come across the Bailey case. So what is this? Sounds like streaming live. Nope. So sorry. Clicked on the wrong one. No, come on. What's going on? Okay, KKS says, caught up on Little Girl Attorney's video. Sounds like she agrees with Cassidy, but what do I know? Somebody saying something in opposition to me? Or but what? Wow, that's amazing. I adore Little Girl Attorney. She is so smart. Okay. So this was the holding. This was the important stuff about this case. So she shared an office and job duties, and one of the coworker that she shared the office and duties with called her the N-word. She reports it, and the human resources manager blocks her from filing a formal complaint. Not only that, but begins to engage in a course of intimidating conduct. Ultimately, says you're gonna get it. Can you imagine? This is not the person who said the disgusting word. This is the person who wanted to file a complaint about it and was stopped from doing it. Thank you so much. Is it Fiji? Shout out to Cassidy for her incredible work. Thank you. I'm starting to get afraid because I see how much time has gone. I'm like, oh, I hope I'm not boring you guys. The trial court granted summary judgment for the city, finding Bailey had failed to make a prima facie showing on her FEHA claims. The Court of Appeal affirmed, and we granted review. So this is the California Supreme Court. This case asks us to assess whether certain conduct. So now, this is, see what I mean? At the very beginning, it tells you what the important bits are. First, we assess whether a coworker's one-time use of a racial slur may be actionable in a claim of harassment. That is, whether such an incident may be so severe as to alter the conditions of employment and create a hostile work environment. Second, we assess whether a course of conduct that effectively seeks to withdraw an employee's means of reporting because they obstructed her and addressing racial harassment in the workplace is actionable in a claim of retaliation. That is, whether such conduct may constitute an adverse employment action. So, all his quotations of Bailey, none of them were about these 2 things. None of them. So they were all dicta. Yet he tells Wayfarer, oh, you can't use that case. You're using dicta for that. What are you talking about, Lewis? Rules for thee and not for me. I feel like maybe he's related to Blake. Because this don't make no sense. All of the things they have in common. All right. And then I also noted underneath the tweet that there was two comments, like right there, right directly under, at the time that I saw the tweet. Which was sometime earlier yesterday. Leanne, I think you guys all know Leanne. Did you see that also he said this, he gets so many facts wrong. Wayfarer hired Jen Abel, even though she was an employee for Joneswork, who was assigned the Wayfarer Baldoni accounts long before the movie and until after the alleged smear campaign was already well underway. We're going to pick at all of this other stuff and then we're going to completely ignore some of the big facts. She was a Joneswork employee even at the beginning of Blake's allegations of retaliation or smear campaign. Remember? Her phone was taken and Blake found out. And Blake was already saying, had already asked Justin and Jamie to take all the blame for what went wrong. There was stuff already going on, accusations already flying, Leslie Sloan already planting stories when Jen was still working for Joneswork. And she had been working for Wave. She was their contact person for, I think it was years, wasn't it? That she was the contact. And that's why Wayfarer said, well, if you're leaving Jonesworks, we're going to stay with you because we have this well-established relationship. So the next comment, now this, I'm not giving this any kind of validation or anything like that. I just thought this was interesting. It's conspiracy theory ish. So that's why I'm saying I'm not giving any validation or support to this argument. I just thought it was an interesting point that I hadn't heard before. Liman is playing for Ari Emanuel. He should never have accepted the case considering his brother worked so closely with Ryan Reynolds and Blake Lively's agent, Ari Emanuel. But I think there were some issues there. It's been a long time. Bachi and I were talking about this last night. Like, we used to have all this recall of everything, but it's been well over a year now. There's just so much that a lot of things that I used to have like instant recall on is just gone. He only dismissed Blake's claim because trial would be horrific for Ari to have celebrities and cast testifying. So not so much the first point there, but that second one made me wonder. A protection of Hollywood of sorts would be an interesting. It kind of goes along. If those of you who read the Eumonia Dyke article that talked about him, the way he rules on anything to do with fraud is what the kind of insinuation that I don't want to say accusation, allegation that she had made about why he rules the way he does about fraud. Could that be? Who knows? Who knows? Nothing would surprise me at this point. So this is the quote in full that gets quoted in these cases. And he extracted a tiny molecule of it and made a Frankenstein monster of it. Sir, this entire code of statutes exists specifically and exclusively for employment. PR is not employment law, no matter how much you want it to be. If I want to know the side effects for my medication, I don't read the user manual for my Wi-Fi router. I read the insert that came with my pills because that's what it's for. You don't try to find a backdoor way to keep a defamation claim in that didn't meet the standard for relabeling it or by relabeling it as employment retaliation and applying it to someone who had nothing to do with your employment. All of the cited cases were situations where the third parties were actually involved in employment activities like hiring, training, etc. It's absurd. He acknowledged that California courts haven't ruled on this and then pushed forth anyway. Maybe they haven't ruled on it because it doesn't belong in this code. Did you think about that, Lewis? Do you expect to find personal bankruptcy law in there too? How about estate planning or child custody agreements? If it's not there, maybe consider possible reasons why that is. How about it probably doesn't belong there because it's not about employment? You are supposed to apply state law, not invent new versions of it. If the action that the so-called retaliation is based on didn't even survive, how is this even happening anyway? You just extended FIHA into an uncharted category of post-employment third-party reputational retaliation without a clear California authority, contrary to principles of federal restraint where you are supposed to show deference to the state's opinion of the law you are deciding. Congratulations, California. You were just gifted new law from New York that you now get to clean up after. I got two more issues that I had with his ruling. One is that he overread Reno versus Baird, labeling illustrative language as authority to expand third-party liability. So this is beyond even dicta. This is like someone giving an illustration. There's nothing applicable about this. Reno did not decide the scope of third-party liability under FIHA. Let's start there. That was not the point of that case. We already learned how to figure out what's holding and what's dicta. We already figured that out. So it's holding addressed whether individual supervisors may be held personally liable for harassment and discrimination under the statute. That's what you quote this case for, nothing else. The California Supreme Court noted in passing that such liability might extend to customers or suppliers in certain circumstances. It did not say would, does, none of that. And it also had certain circumstances attached to it. But that observation was not just dicta, it was illustrative dicta, not a holding defining the outer limits of statutory liability. But Liman treated that passing reference as affirmative authority for imposing liability on an external PR firm engaged in reputational support. He tells Wayfarer not to use dicta and then does this. He converts dicta intended only to illustrate the conceptual possibility of outside assistance into substantive authorization for a novel and expansive liability theory. Illustrative examples in judicial opinions cannot be transformed into broad doctrinal rules detached from the issues actually before the court. Reno did not analyze whether an independent contractor performing public relations services could be liable for alleged retaliation, nor did it interpret FIHA to encompass external communication strategies unrelated to personnel management or workplace supervision. Absent controlling California authorities squarely addressing such circumstances, Reno cannot bear the interpretive weight that he assigned to it. Its dicta does not establish that any external service provider, particularly one engaged in non-employment functions such as media strategy, falls within FEHA's aider and abetter framework. This was a misapplication. It was an overreach. It was an overread. It was taking someone's musings and using them as authority to make a new law. Here's another issue. I mentioned this earlier. We have another unpublished case rearing its head. He did this before when he couldn't find supportive case law for a decision that he made. How alarming is that when we have regularly seen this judge either do a whole page like a Natasha Heath's, his order about Natasha Heath's birth video, not a single authority listed, no case law to support that decision. The other thing I talked about when I forgot what I was going through the other day, and I showed you again, I'm like, what's missing on this page? He's making plenty of claims. He's making plenty of decisions, not a single case law. And now we have the second time of an unpublished case. These have no power. California doesn't even recognize them except for very limited circumstances. But he, from New York, to change California law, he uses an unpublished case, something they wouldn't even recognize. So it's Hedgepeth versus City of Anaheim. Now, what were the holdings in this case? It involved, or it concerned, well, actually involved concern. Oh, sorry, I put two words there. Involved or concerned a former employee who alleged that his former employer boycotted his training courses and publicly announced that it would continue doing so. Nothing to do with Blake's case. The critical distinction is who acted and how. Did we have an outside PR company doing something, or did we have his employer? Was the conduct tied directly to commercial dealings affecting the plaintiff's ability to work in the same professional space? Yes, we did. Whereas Blake had already finished her, well, she never signed the contract, but for lack of a better way to express it, she had finished her agreement with them. So these do not apply to her case. These actually go against her case. The employer's actions had an operational, you could tell I was getting frantic trying to hurry up. I messed up my spacing here. The employer's action had an operational business relationship to the plaintiff's employment-related opportunities. It does not address third-party aider and abetter liability. So why are you quoting it? Which is what's at stake in Wayfarer versus Blake Lively, and so it fails to resolve the issues here. Blake's case speaks on post-employment issues. No. This case speaks on post-employment issues with a direct employer, not external reputational activity. California rules generally prohibit citation of unpublished decisions. This was about how this is the one that talked about his future ability to obtain or retain work as an instructor. Yeah, the guy kind of ruined his reputation. So it will definitely could it arguably affect his future prospects. You know, if you try to get another job and you've got people who might say something bad about you, your former employer won't give you a recommendation. It does affect. But the point is, the important facts of the case were completely different than Blake's. All right, and now to start to summarize all of this, this is what I mean by when I say California has got to clean up after this mess that he made for them now with his gift of a new law. If public statements or reputation attacks, what he's saying that tag did, can count as workplace retaliation anytime they affect future job prospects, even after the employment is long over and it's a third party person, then the law could expand far beyond the workplace. That could pull in social media posts, industry gossip, press campaigns, reputational disputes. It turns employment law into general reputation protection law. We already have laws for that. It opens the door too wide, and who knows what could get drug in. That's the danger. All right. So, in summary, the biggest mistakes I feel like he made was his misapplication of Janowitz to post-employment conduct. It didn't talk about that. Improper reliance on dicta and Bailey while telling Wayfarer they couldn't do it. He didn't take the holdings from those cases. He grabbed stray little cherry-picked moments that would help him make this ruling that he wanted to rule on. If you've got to go through, how did you find those cherry-picked bits? Right? You're supposed to be going through case law to come up with your ruling. What are you out here searching that you're finding these little cherry-picked bits to try to claim your order's correct? 3, improperly treating illustrative language as substantive authority for overly expansive third-party liability. You don't take someone's musings and say, okay, this is the authority that I need in order to give the state a new law. 4, federal court expansion of unsettled court state law, that eerie concern. I showed you that article that was written about it and how even the Ninth Circuit Courts of Appeals feel about that. They are humble. They want justice served. So they recognize they may not be as familiar as they need to be to make that decision, and they humbly defer to California. 5, he used an unpublished case to support such a bold move when actual case law didn't suit his purpose. And California doesn't even recognize it, and the case didn't even match the case he was trying to support with it. 6, turning employment law into a backdoor defamation claim or a general don't hurt someone's reputation law. Those laws exist already. She failed her defamation claim, and now you're giving her this backdoor and abusing employment law to do it. Okay, guys. Just over 2 hours. Sorry that was long. It always happens. I always think I'm going to go shorter, and I never do. But I've got a few minutes. I'm really dying to go watch Little Girl Attorney. Have Brittany or Not Actually Golden or Ron Zambrano said anything yet? Do you guys know? I want to go watch all of those. But if you have any questions, I will try my best to answer if I know the answer. Oh, CM Baby, I saw, but I didn't want to interrupt again. Thank you so much for gifting the memberships. You're so sweet. Oh, wait. Clicking around on. Sorry, guys. Not Actually Golden made a statement, but you don't agree. They're both scratching their heads over this. Yeah, there is a tendency to try to not go against a judge, that some is just, and I don't want to say anything bad about that. Like they have been programmed for decades to honor these men, and they're not going to say something bad about them. She sided with the judge. Oh no, maybe I won't watch that one. I don't want to get mad at her because I like her. Obachi's life. I'm going to head over there too. Little Girl Attorney, the California employment lawyer. So hers makes more sense. Yeah, I would definitely go with, and the nice thing about Not Actually Golden is she will defer to little girl attorney. She will say, "I'm gonna talk to her about it," or she's the one to ask about this because that's her expertise, which I think that says something nice about a person who recognizes that. Little girl attorney is not scratching her head. She's come up with a reason why she believes the judge is wrong. Go, little girl attorney. Rose is Wild, I thought Not Actually Golden's first video implied he made up a lot of fit, but her second video said she don't want the judge attacked. Oh, so she's made two. Not Actually Golden did a short telling her subs that if they think Lyman is biased, they're trying to flex and don't want to know the facts. Well, I do have to say also, if you just do a short reading of an order and you don't dive into the case law and the rules and you don't go deep enough, maybe you don't realize what all the issues are. And I have a little more time than these people. I mean, these are working attorneys. They've got their own cases they have to keep straight in their heads. They can't give enough brain space to these things. Rosa said, I thought, did I? Oh, I already read that. Sorry. The picture of Blake is all. I think it was joyfully observed. I think is the one on X that I got this from. Okay, you haven't watched. Yeah, I haven't watched either. I don't usually watch anyone else's until I've made mine because I don't want to be affected by somebody else's opinion. Nag always tries to make the judge's ruling make sense. That's just how she rolls. Oh, Glory's going to Bocce's. Yeah, I'll get off. I don't want to be on a competing live. I've had my time. She told me she did an 11-hour live before. I couldn't believe it. Hey, oh my lord, thank you so much. I live in Southern California. Who dug this? Well, write him a letter and tell him you're not interested in him changing your laws. Oh, that's because she is. He needs to hire you for research, Cassidy. You would keep him honest. Oh, I'm sure he would hate me if he ever heard anything about me. Well, I'm sure he didn't like my filings. All right, guys. Well, I'm going to go ahead and call it then and head over to Bocce's. I'll see you guys there. I'm going to grab some food. I had a few bites of ice cream at Costco today. I think that might be all I've eaten. Just too much going on. Anyway, no, I had some crackers and cheese. I did. Okay. All right, guys. Thank you so much for. Sorry, I ignored the chat, but I mean, this was over 2 hours. Imagine how long it would have been if I had been talking to you throughout it. Anyway, thank you guys so much. Thank you, Christina. Thank you for all of the memberships and the super chats. And I hope to see you guys soon. And I hope we get some better rulings in the coming days. Bye-bye.